The Fulton County ballot audit happening right now in Georgia may be running into a little bit of a snag, with someone alleging to be a new party actually coming in and saying they have not been properly served. They have asked for a stay on all proceedings pending service and their opportunity to respond. This is potentially a pretty big delay tactic. So let's take a look at what's going on and talk about it. I'm Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you may be watching, go ahead, hit that like button, hit the subscribe button, and make sure you turn on your notifications so you don't miss any videos. All right, so what are we talking about here? This is breaking news out of Fulton County, Georgia, and this is coming from Real America's Voice, Heather Mullins. So the Fulton County Board of Registration and Elections has hired two of Georgia's top criminal defense attorneys and filed paperwork to halt the audit proceedings previously ordered by the judge. And the story is unfolding on RAV. However, we have the documents available here, courtesy of RAV procuring them. So what's actually going on in this thing? Well, if you remember, just a couple days ago, I did a video about the Fulton County ballot audit. And in that, the judge has ordered the unsealing of approximately 145,000 absentee ballots. Those ballots now being unsealed need to be imaged with some very specific specifications, like 600 DPI imaging, which is a pretty high resolution image. And they're going to take that image and turn over the images of the ballots to the auditors. They have determined, or the judge has determined, I should say, not some elusive they, but the judge has determined that the state is not allowed to turn over physical copies of the ballots due to issues around election security. And there's some sort of look towards what has been going on in Arizona, a move turning over the actual physical ballots to a third-party company, Cyber Ninjas in Maricopa County. That has triggered some people, and they have said that that is somehow breaching election security and integrity, and by doing so, they have corrupted the process. So the judge here was aiming to avoid some of those criticisms. Instead, he said that the state themselves would unseal the ballots, would go ahead and make these high-quality images, and then the images themselves would be sent over to the auditing company for review. With those high-quality images, they would be able to take a look at the ballots and determine if there were inconsistencies among them. So it's important to note that in this Fulton County case, they are not actually currently seeking to decertify election results, and the wording of the lawsuit itself does not currently allow for that sort of remedy. So this lawsuit in Fulton County is not intended to decertify any election results or anything like that. As I've said in all of my videos, what these lawsuits, what these audits are doing, and this is why they're actually sort of growing in popularity amongst Republican states primarily, is that these audits are giving information to the different legislatures of these states so that they can make proper determinations about what election laws they want to pass, review, modify, or scrap leading up to the next election cycle we have coming in 2022, and then, of course, the next presidential election in 2024. They have some level of right as legislatures to go ahead and get this information from the county and state election boards so that they can make proper determinations on which laws to pass, as that is their constitutional authority, both at the federal level and within their state constitutions. So that's what they're aiming to do at present. It doesn't mean they won't change the scope of the lawsuit. If some big bombshell were to happen in Fulton County, they may try to get a judge to decertify the election results. But at this point, that is not presently in the lawsuit. So what we're talking about now is looking at the integrity of the absentee ballot process in Atlanta, which was under a ton of scrutiny during the election, and seeing if there are holes and gaps that can be filled by tweaking existing law or making new law entirely. All right. So with that background out of the way, let's go ahead and take a look at the documents. It's a 4-page document. It's not very long, and we're going to hit the main part. So right here in the introduction, we have the respondent being the Fulton County Board of Registration and Elections. They filed this request for a stay without waiving its right to be properly served and provided an opportunity to file responsive pleadings. So whenever you have a lawsuit, all of the named parties in the lawsuit need to be able to, one, have been served, and two, they need an opportunity to respond. The service part is generally controlled by state law. There's a set of civil procedures in the state, unless it's a federal case. This is a state court case. So as they follow these state civil procedures, and then they will serve the defendants, all of the respondents, I guess, in this, because this isn't complainant and defendant, it's petitioners and respondents. So they're there to serve all of the respondents. And so you may ask, well, how did this thing get so far without them being served? Well, that's because apparently, and this is where the confusion comes in from these documents, this party was added to the lawsuit just recently, back in April. But the way this is worded, I'm not 100% sure they were actually added to the lawsuit. That's a little bit unclear. Let's read on. The Fulton County Board of Registrations and Elections, the BRE, is now a named defendant in this action, having been added to this civil case by order of the court on April 21st, 2021. Now we've got a footnote down here. The respondents filed a motion to substitute the BRE on January 27th, 2021. Okay, so the respondent said, we're not the right people. We want you to substitute in the Board of Registration and Elections. In the court's order granting the petitioner's motion on April 21st, the court did not indicate how exactly the respondents did not object, given the fact that respondents, the Fulton County BRE and Fulton County, were not served with petitioner's motion, and no attorneys had filed an appearance on behalf of either BRE or Fulton County. So we've got the respondents filing a motion for substitution, and then they're talking about the court order granting the petitioners, those are the other parties, their motion for the ballot review on April 21st. What we don't have listed in here is the order for the actual additional parties being substituted in. We don't have a citation to a ruling, and that's where I'm a little bit confused about this case. I'll be doing a little bit of further research, but I assume we'll also get some more information as this unfolds. But it doesn't look like there's an order actually adding the Board of Registration and Elections as a substituted party in this matter. It doesn't appear that that has happened. And they don't reference the actual order granting it. They just say they filed a motion, but it doesn't look like they've gotten an order on that motion. Typically speaking, if you're going to say, hey, judge, you did this, you did it on this date, here's the motion, here's the citation to it, or here's the citation to the order corresponding on the motion. But we don't actually have that here. So I'm not quite sure what is happening with that. But with all of that, we actually don't need the rest of the pleading document here. We don't need to go through the other pages. I'll just explain the rest. But I will drop a link to this tweet down in the description so you guys can check out the filing for yourself. But long story short, parties have a right to notice and an opportunity to respond. We do that through service, that's the notice, and the opportunity to respond is through the civil procedure laws in every state or at the federal level. There's a set of procedures that happens once you are served, and then that is your opportunity to respond. They have to go ahead and make an appearance. They have to file a response to the service. That way, when any motions are made, they have an opportunity to say, you know what, I don't think so. I don't think so. That's not the right thing. Now they're saying that they have motions that they want to file that preempt this current order, the ballot order, and those motions would be something called a dispositive motion, like a motion to dismiss, where it changes the disposition of the case from an open case to a closed case. So they have plans to try and get this thing dismissed, try and shut it down. That's what they're ultimately trying to do, of course. As we all know, they're very, very afraid of these audits. in every state, they're terrified of the audits. And it's amazing to me because if you've done everything correctly, you should have nothing to fear from an audit. Minor discrepancies in something is not going to be big news. So as long as they followed proper procedures, as long as they have a consistent vote count, and as long as the ballots that they used in their own vote count hold up to scrutiny, there shouldn't be any issues. Again, having even 100 ballots being out of place, that's not even a normal rounding error in the average election in a place as big as Atlanta. So really, they shouldn't be afraid of this audit unless they're afraid of the audit. But it seems like in every state where these come up, there's a ton of resistance to it. And we've seen this resistance going on from the 2020 election. And this is part of the problem. It's the resistance that is raising people's questions, suspicions, and concerns about this stuff. When people ask, hey, we just want to make sure everything happened right, and someone else screams at them that they're a racist, a bigot, and that they definitely are trying to steal an election, then that kind of makes people like, wait, why are you so worried about us just looking at what happened? That's why people are concerned about this. At least that's my takeaway. Why don't you tell me yours down in the comments below? We'll be following along with this. This case is getting more and more interesting, and the procedure aspects of it are suddenly very weird. You've got two parties who apparently haven't been served, but may not even actually be parties. It might just be kind of trying to pretend they are. We'll see how it goes. Maybe the judge missed a motion. You never know. In court, a lot of different stuff can happen. So thanks for watching. Until next time, peace. Peace.